direct examinations. This video is for law students, new lawyers, or old lawyers that hadn't done a trial in a while. So when we talk about direct, there are some general rules. And keep in mind, I am saying general rules, so there are exceptions, but the general rules are things like don't ask a witness what they think or what their opinion is, because it calls for speculation, and that's going to be objectionable unless they're an expert witness, and that's going to be a different video. Don't say, what'd you hear? Well, what'd they say? What'd they tell you? Because that's going to call for hearsay, and that's going to be objectionable. You know you have to lead a witness. Now, I hear you. Some of you are going, well, we're not supposed to lead the witness. No, you're not supposed to ask leading questions. But you dang sure better be leading that witness. This is called a direct, and it is your job to direct them where you want them to go. And you can do that. You just can't tell them what to say, and you can't say, here's the answer. Is that right? So, the don't put words in my mouth. You remember that from the schoolyard? So when you were in elementary school or middle school, high school or college for some of you, you get into an argument and say, don't put words in my mouth. If you are putting words in their mouth, that's a leading question. Now, a lot of people say, don't ask yes or no questions because those are leading. Those are not always leading questions. Officer, did you search the car? That is not a leading question. It does call for a yes or no. So keep in mind that you just can't suggest an answer in your question. The other rules that you want to really think about is, should I ask it in a chronological order, or should I do it in a more impactful way? Because a lot of people say it should always be chronological, and that's not always true. Sometimes you want to get the most impactful statement from the person right at that moment. What do I mean? You've got a robbery case, you're a prosecutor, you're prosecuting it, you get the victim up there, and when they first talk about the robbery, you ask them, how did that make you feel? Get that emotional part, because remember theme and theory? Get that emotional part right out front to grab them. You can fill in the details later. But how do you even set up a direct? Well, stay away from a script. There is very little more boring than just going through the script saying, what happened next? And then what did you do? Stay away from the script. Remember, every time you question a witness, whether it's an expert, whether it's a direct or cross-examination, it is a conversation that you're having. The jury or the judge, they are listening in on this conversation. So forget what you've seen on TV and just have a conversation with the witness. Which means when they say something, it's okay to say, no, wait a minute. You found a gun under the seat? Where exactly was it under the seat? Was it shoved way up under there? Or was it right on the edge? So it's okay to ask those questions. It's okay to slow your witness down and control them and make sure that everybody understands the full impact of their statements. Because remember, theme and theory, emotion carries the day. When you are going from question to question, make it transitional. Don't just jump in there with something that's totally off the wall, because we don't do that in conversations. Well, some of you do. I mean, squirrel! But you shouldn't do that. Make it transitional, make everything flow, make it make sense. So when you are preparing for what questions to ask, you want to think about, what is it that I need to prove my theory? Remember, theory and theme. What are the facts that I need to elicit from this witness? Now, a good place to start is always with your jury instructions. What are the elements? So if you're a prosecutor or if you're a plaintiff's attorney, then what are the elements that I must prove? What witnesses am I going to use to prove those elements? And then you need to figure out the questions to elicit that information. If you are a civil defense attorney or a criminal defense attorney, then it's what defenses do I have available, or what facts do I pull out of what witness to show that this element was not met. And so jury instructions are a great place to start with that, because you're always going to have to either meet those elements or show that those elements were not met in every trial. Don't script it. I know I've said it, but I'll say it again. Do not script. Do not stand there with a notepad reading from it. Do not say, and what happened next, and what happened next, and what happened next. Because you can have the best case in the world, but if your jury is asleep, they're not going to hear it. So those are some good general rules for direct examination. And there's a lot more to it. But if I had an hour-long video, y'all might not watch it. So, good general rules. Do good work.